But today's business is a paper by Professor Xiaobo Zhai, and Xiaobo first came to the Bentham project. I wish I could say it only seemed like yesterday, but it was nearly 5 years ago, wasn't it? 4.5 years ago, as a Newton International Fellow. In the first tranche of the fellowships, which were funded by the academic societies of the UK, and I think that's the only time I've ever seen him wearing a suit and a tie. So he's almost got there today. But Xiaobo spent 2 years with us at UCL, having come from Peking Law School. And whilst he was here, he changed affiliation and returned to China as a professor at Zhengzhou University, where he organised a very successful Bentham conference, and the papers from that conference will be appearing in a book which Cambridge University Press are publishing on the 30th of April. But Xiaobo came back to the UK and is working on Bentham's legal theory and paying particular attention to Bentham's early jurisprudence. So Bentham's writings in the 1770s, early 1780s, when he was working out his fundamental ideas and criticising in particular the work of William Blackstone. So we're looking forward. I'm looking forward very much to hearing what Xiaobo has to say on Bentham and the common law, Bentham's exposition of the common law.
Thank you. This talk is part of a big project on Bentham's general theory of law. The task of this paper is to see what we can learn, what lessons we can learn about the Bentham's general theory of law from Bentham's exposition of common law. Bentham is well known for his critiques and denunciations of common law, on which very much has been written. This paper tries to give an account of Bentham's exposition of common law, which paradoxically has received little attention. Common law has at least three senses. First, common law as a legal tradition, as contrasted with civil law. Second, common law as the law administered by common law courts, contrasted with equity. Third, common law as judge-made law, as contrasted with statute law. In this paper, common law is understood in the third sense. I will start with a very brief account of Bentham's apparently self-contradictory remarks on common law, which, according to Bentham's considered view, is fictitious law. Then I will try to present Bentham's two attempts of paraphrasing common law in terms of judge's words. The first is an inconsistent effort focused on the question whether judge's words contain authoritative and general mandates. The second is a highly sophisticated analysis of the complex relations between judge's words and customs. Bentham thinks common law is more like these are his critical general comments on common law. He thinks that common law is more like a model than a system, a labyrinth without a clue, the cobweb of ancient barbarism. I quote, "In common law, various rights and duties of various classes of mankind were jumbled together into one immense and unsorted heap. Regarding the form, the words that, the form of common law, the words that Bentham uses to describe common law are as follows. I just give you a list. Imprecise, unclear, obscure, non-cognizable, not public, inaccessible, technical, complex, inscrutable, incomprehensible, mysterious, inconsistent, self-contradictory, over bulky. Bentham thinks that common law is composed of private and subjective sentiments rather than public shared standard. Common law is retrospective dog law, and there's a vicious circle of arbitrariness inherent in common law. On the one hand, is a strict but also blind adherence to precedents. On the other hand, is the manipulation of the meaningless and therefore Panthean concept reason. So these defects are partly the result of the device of fiction, which is used by lawyers, with sinister interest, to develop common law. The consequence is that common law cannot bring security, certainty, cannot provide guidance for people, cannot focus or guide people's expectations. It just plays on people's blind fear. So rational and responsible obedience is impossible. These are Bentham's, a very brief account of Bentham's critiques of common law. Then we see Bentham's very violent denunciation of common law. Bentham thinks that statute law is okay. Statute law is real law, really existing object, the only real and genuine object. But common law is unreal, not really existing, counterfeit, spurious, pretended, sham law, imposturous and mock law, imaginary law, and common law is a fictitious law. The puzzle is Bentham's praises of common law go side by side with these denunciations. For example, he says that common law is, I quote, a rich storehouse of materials for legislation. Without it, no tolerably adequate system of laws can be made. Common law functions as a light to the legislator to assist him in the making of real law. So for legislator, common law is a matchless blessing. And also, Bentham's definition of a law applies to common law. According to Bentham's definition, a thing, in order to be a law, needs to have two qualities. The first is it is an expression of will concerning people's behavior. Second, the source and force of this will can be traced ultimately to the sovereign. Bentham especially warns against identifying laws with legislated laws, and he argues that laws include judicial orders which, I quote, except not emanating directly from the sovereign power, agree with those which are universally and without scruple termed by the name of laws. He argues that the real difference between common law and statute law only lies in their form, which makes no difference to their status as law. I quote, a law is an expression of will, that is, an assemblage of signs expressive of an act of the will. These signs then may, by possibility, be any signs whatever which are capable of expressing such a will. the behavior of him who, instead of saying, put to death the chief leaders of the people, smote off the tallest heads among a parcel of poppies, might, instead of being an advice, have been a command. The end of the quote. So for Bentham, the laws of common law, to appearance, are particular to appearance, just to appearance, are particular autocratic acts or orders. Their verbal discourse is particular, but they have somewhat of the effect of general law in virtue of the more extensive interpretation which the people are disposed to put upon them. Because the difference is just a matter of form, so common law, according to Bentham, can be easily converted into statute law. So conversion is a change of form, not substance. Yeah. So the impression is that Bentham, the thinking about whether common law is at root very much like, I know this will definitely be very controversial, is at root very much like that of natural lawyers. Common law is law, analytically and factually, but it is so bad in performing its functions, in guiding people's conducts and creating certainty, that Bentham is not willing to call it law. Bentham, although crucifying this mode of natural law thinking and speaking, confesses that, I quote, this is very interesting, I might also very likely declare that it is common law was not law, because the phrase or this formulation, though affected and not precisely just, is a common one. So, okay, if common law is fictitious law, then we need to know its nature and its mechanism. Now let's go to Bentham's Periphrasis of Common Law. Bentham, we all know that Bentham hates common law. He pours out upon common law all invective that is available to him. And for long, Bentham's strong and emotional vituperation against common law has prevented us from appreciating his profound insights on the nature or mechanism of common law. Now I will pierce through Bentham's abusive rhetoric to his sophisticated analysis of the operation or mechanism of common law. According to Bentham, common law is fictitious law. Nobody can show you a common law, but we can, as Bentham does, paraphrase common law. Bentham's Periphrasis of Common Law has two steps. First, he looks to the common law books, and second, he imagines the correspondent article of statute law that shall represent a possible law of common law. Books of common law are made of either judge's words or non-judge author's words. I will not discuss the law status of non-judge author's words. Instead, my focus is judge's words, which include, I quote, the decision said to have been pronounced on each individual occasion with the argumentation by which they are said to have been preceded, and the rules which in the course of that argumentation are supposed to have been laid down as referred to. The end of quote. People gain access to and people learn common law by studying judge's words. In my talk, judge's words and judge's decisions or judicial decisions are used interchangeably. Bentham does not deny that there are rules laid down in judicial decisions. What Bentham argues is that if common law exists in judicial decisions, then it is made by judges, which who Bentham sometimes claim do not have the authority to make laws. It is perplexing that Bentham thinks judges have no title or authority to make laws, given that judges' decisions are habitually obeyed by relevant parties and followed by other judges of equal or lower ranks, and that judges can give to their decisions the force of law, which ultimately derives from the sovereign. Bentham contradicts himself, asserts elsewhere and very frequently that acts of judges are acts of authority. Another problem is the particularity or the particularity of judicial decisions and the generality of laws. Occasionally, Bentham seems to have forgotten that a judge's words contain the argumentation by which judicial decisions are said to have been preceded, and the rules which, in the course of that argumentation, are supposed to have been laid down as referred to. Capitalizing the apparent particularity of judicial decision, denounces common law as non-law on the grounds that, I quote, where there is of law in the case must be general. What there is of law in the case must be general, applicable to an indefinite multitude of individuals, not then assignable. So nobody denies that judicial decisions or rulings are particular. And nobody argues that particular judicial decisions bearing upon the individual person or things are rules of common law. The rules of common law are the general rules that judges use to make their particular decisions. Or to use Bentham's formulation, I quote, the rules which have been laid down as referred to. Facts can only yield judicial decisions when combined with a general rule which gives legal meaning to the facts. But judges may not explicitly formulate or articulate these rules in general verbal discourse, but implicitly use, or to borrow Bentham's words, act upon them. Later interpreters can find out the rules that judges use by working back to the rules from the facts and the decisions. So this explains why Bentham agrees that these, I quote, these particular autocratic acts or orders, which in virtue of the more extensive interpretation which the people are disposed to put upon them, have somewhat the effect of general laws, and that, still I quote, the rules that are fairly to be drawn from prior decisions can answer the purpose of a law if they are conformed to in subsequent decisions. So the process of working back to the general rules from the facts and the decisions might be full of indeterminacies. However, these uncertainties are also mitigated in many, many ways, especially when the interpreter is a judge. I quote, his conclusions will naturally carry more weight with them than those of a common man. He will naturally be supposed more likely to form such conclusions as shall be the same with those formed relative to the same matter by others that are judges. His character of a judge is a certificate of his possessing a certain degree of experience and discernment, and, in short, a habit of thinking analogous to that of his brothers. The end of the quote. or the second step of Bentham's paraphrasing common law. That is, the relation between judicial decision and customs. According to Blackstone, first, common law rules existing in judges' words are evidence of legal customs. Second, these customs receive their binding power and the force of law by long and immemorial usage. Third, these legal customs, enjoy universal reception throughout the kingdom. Here we have three theses. Blackstone's view on the relation between common law and custom is, we can see that it's the basis of the other two theses. So now I will just focus on the relation between common law and custom and start with Bentham's conceptual analysis of custom. First, types of customs. In legal context, the word custom has a peculiar sense, different from but liable to be confounded with its common sense. In its ordinary and popular signification, common law is custom is referred either to a single person or to a multitude. Bentham defines the custom of a single person as an assemblage of successive acts of his that shows an uniformity or similarity, that is, of the same kind or description. When we say at a given time that somebody has a custom of doing something, his acts of doing something are all past rather than future with reference to that given time. To say somebody's custom is that he shall do something, according to Bentham, is absurd. The custom of a multitude of persons, Bentham claims, is an assemblage of their simultaneous or successive acts which are uniform, or same or similar. Like the custom of a single person, the custom of many persons only refers to acts of the past. It would be a manifest mistake to say that it is a custom that we shall do something. In the ordinary and popular sense, the acts constitutive of a custom are all spontaneous. We will call them custom imposed or spontaneous customs. A legal custom is a much more complex idea. A legal custom is a custom that is obligatory. A custom can be obligatory only, according to Bentham, only when a person is liable to punishment for not observing it. A legal custom, as a necessary constituent part, involves the idea of punishment. Only in this sense can a custom be applied to future acts. When we say that it is our custom that we shall do something, we have used this word, the word custom, in its legal sense, because we have intimated an obligation in us to perform something in future, as we have already done in the past. However, Bentham seems inconsistent at this point, because apart from customs in legal sense and those in ordinary sense, he also accepts that there is another different type of spontaneous customs in pay. For instance, the custom that a carrier shall make good the loss or damage happening to the goods entrusted to him by the owner. The owner expects the carrier's answerability, and the carrier is sensible that it is expected of him and prepares himself accordingly. He has reason to think that he would be thought to have acted unjustly and be liable to lose the goodwill of his acquaintance if he does not make amends upon a loss or damage happening to the goods. Bentham acknowledges that this is a spontaneous custom which applies to acts in future, and it is maintained by popular or moral sanction based upon a network of mutual expectations. We will term this type of custom and popular customs or customs of public opinion. It is in this sense that Bentham sometimes says that a custom may command somebody to do something. Apart from being spontaneous custom in pay, this type of custom is essentially no different from legal customs because they are imperative and can be applied to the future, and their breakers are liable to be punished whether by popular sanction or by judicial sanction. Bentham even claims that points of law can originate from popular custom. Linking this with Bentham's thesis that a political constitution is law in principle backed by sanction of public opinion, and his thesis that different kinds of sanctions are the same in being pain, it is not unreasonable to argue popular customs are also legal customs, and that one implicit theme in Bentham's legal theory is that law includes two types: law backed by sanction of public opinion and law backed by formal legal sanction, which may include another further two types: the sanction decided by the judicial branch and the sanction decided by legislative sanction. This further bifurcation leads to Bentham's comment that, I quote, "Of law, customary judicial punishment and authoritative legislative command are the only two sources." So as a diversion from the main theme of this talk, I'm inclined to make a tentative suggestion. That is, Bentham's law includes three types: legislative law, judge-made law, and public opinion-made law. Okay, let's go back to Bentham's conceptual analysis of custom. Custom can, according to the nature of the benefit derived from customs can be divided into two types. The first type is the customs that are active in the favored party and passive in the burdened party, such as a custom regarding the benefit of property in a thing. The enjoyment of the property consists in the former's exercising acts of ownership, while the latter forbears to oppose them. The second type is those that are active in the burdened party and passive in the favored party, such as a custom regarding the benefit of services of a person. The receipt of the services consists in the former's serving the latter, while the latter forbears to oppose them. This distinction is very, very important when we are talking about whether a custom can be spontaneous or can be immemorial afterwards. Now let's have a look at the process how a custom can become a customary law. As shown above, in an ordinary custom, there is nothing to make it obligatory or an article of law. It is not that my having done something 100 times that obliged me to do it the 101st time. Bentham argues that it is only by making it punishable for me not to do it that I will be obliged to or shall do it. To punish the non-observance of a habit or custom is to legalize it. Let's illustrate this legalization with the example of the popular custom between a carrier and owner mentioned above. I mean, in the process of time, for example, a certain carrier damaged the goods and refused to make amends for whatever reason or pretense. The owner convened him to the judge, who heard the cause and decided in the owner's favor. The judge, in consequence, made it clear to the carrier that he must make good the loss or be punished. From this moment, according to Bentham, this is an example or illustration from Bentham. From this moment, Bentham says, the former custom of public opinion becomes a legal custom, a customary law backed by a legal sanction. The justified reason of legalizing a custom is to protect expectation utility. If A has habitually forborne to hinder B from enjoying a property, then B may expect to acquire or to continue to enjoy the property. So habit is one ground of expectation utility. The other ground is promise. This is the first element or first ingredient of common law. The second is custom in foro, legalized. A custom in foro is by definition different from a legal custom. It is a custom among judges at a certain level. It may also be legalized by an act of judges at a higher level, and so on, through many degrees. However, Bentham points out there is a difference between the legalization of a custom in pay and that of a custom in foro. To legalize a custom in pay, the necessary punishment is inflicted upon or threatened of persons whose custom it is. To legalize a custom in foro, the necessary punishment is not, to appearance, in the first instance, the punishment of persons whose custom it is. A judge's sole occupation is reducible to, and their custom consists in, punishing or determining whether punishment shall be administered or not. In order to legalize a custom in foro, it is not, to appearance, necessary that the person whose custom it is shall be the object of punishment. I quote, "To legalize such a custom, it is, to appearance, sufficient that the command of the non-conforming judge be encountered by an opposite punitive command of a superior judge, taking the suitors for its objects. That is, to use the current phrase, if it be reversed by a judge of a superior court." However, Bentham emphasizes this is only the case in the first instance. For, I quote, "If the inferior judge proves refractory, and persists in the enforcing of his order, it is plain that ultimately it is his punishment that will be necessary in order to make the custom he would depart from binding on him, and
difference between the legalization of a custom in pay and a custom in foro is just to appearance. For at bottom, I quote, "It is unquestionable that by the prospect of his own punishment only can a man be bound. In the mind of a judge," I quote, "to feel incessantly the control of a superior judge, the idea of a counter-command by such a superior, and the punishment annexed to the non-observance of it are so intimately associated that the first is understood to have the same effect upon the inferior judge to make his custom binding on him as the prospect of a specific punishment has upon the ordinary subject." So I think this is very important, especially when Hart, in his concept of law, says that Bentham's or the traditional command theory cannot explain the difference between nullity, N-U-L-I, nullity and punishment. I think for Bentham this difference does not exist. According to Blackstone, the common law is a custom of the kingdom evidenced by the determination of the courts of justice. This is wrong, as Bentham argued, because an ordinary custom by itself only refers to past acts and is not obligatory at all. Customary law is not composed of ordinary custom in pay, but customs legalized. A judicial decision does not just evidence an ordinary custom. The judge, by means of a judicial decision or by means of first punishing the non-observance of it, makes or creates or constitutes a legal custom by transforming the ordinary custom. So now we are in a position to give a complete explanatory description of a customary law. Regarding a general rule of a customary law, its terms are of those who expresses it, but its import has been deduced by all lawyers, or including judges, from the observance of a custom. It is produced originally by the force of some judicial decision, enforced and kept up perhaps by a correspondent custom in foro, by habit in judge of deciding whenever the same point in question happened to come before them, of deciding as if there had been a positive statute law to that effect. The third ingredient, single mode of acts legalized. Customs in pay legalized and customs in foro only make up a tiny part of the ingredients of common law. The ingredients that I quote Bentham, has much the largest share in the composition of common law, and that is wholly out of view with Blackstone, is single judicial acts serving to legalize single modes of conduct in pay, which do not find any other similar ones to coalesce with into a custom, and are perfectly detached and singular. A judge can legalize an individual mode of conduct in pay by a single act in foro. In this circumstance, the legalizing act is an act referred to custom, because it is done in conformity to, habits of proceeding in the same court of similar identical description. The judge, I quote, frames his decision upon the pattern of preceding decisions of his own or his predecessors. This is very important. Whether the acts serving to legalize such a mode of conduct have been more than one, so many more as to have grown into a custom in follow, makes no difference, because one single judicial decision unreversed is as much as is necessary, at least with respect to the individual persons and things that are the objects of it, is as much as is necessary to establish a point of law. So that's the Bentham example of legalized single mode of acts legalized is a perjury. I will not go into the detail. What I have discussed so far is the legalized ingredients of common law, no matter at what level the legalization takes place. However, common law lawyers do not care about, they do not have the willingness or ability to investigate the judicialization or legalization process that happened at local or obscure levels. And they are mainly concerned with customs before the so-called common law courts. So Bentham then considered the three status of the apparent customs proposed for legalization or disallowance before common law courts. According to Bentham, they are usually of three types. Some of them may be purely spontaneous. Some of them, in its origin, are spontaneous, but since that already imperfectly or provisionally legalized by inferior or local courts. Imperfect legalization by inferior and obscure and forgotten local courts, according to Bentham, and its original spontaneity, and gives this custom a fresh start. The motive that maintains such a custom after it has been legalized is the sense of legal obligation. It is the sense of legal obligation that does the business. In this case, the utility of further legalizing it may in general be deemed greater than in the first case, customs which are completely spontaneous, because the first step of legalization has improved the public's expectation of its being conformed to, and thereby increased the public's pain of disappointment in case of this expectation being disappointed. Most of these the customs before common law courts in their origin are not custom, are not spontaneous. They were compulsory, resulting from the legalization of a single article of conduct by court below, by local court. So many legal customs, unlike what Blackstone describes, according to Bentham, start as single modes of behavior legalized by acts of local or inferior jurisdictions, which very often lack regularity and consistency and have not been recorded. I quote, "The epoch of the first decision forming a custom in pay or giving legality to one already formed was involved in the same obscurity as that of the first act of a custom purely spontaneous. So it is Blackstone's regarding the court below or the local courts as nothing that leads him to mistake a custom compulsory in its origin as a custom originally spontaneous, and thereby immemorial. So customs, according to Bentham, customs bearing hard upon the party burdened could never have been in their origin spontaneous. Disputes and litigations must have first arisen and have been carried before the tribunal of the place, and that tribunal must have decided in favor of the preferred party. This decision then must have been the beginning of the custom. So whether a custom is spontaneous or originating from compulsion, the following circumstances will be able to give us some clue. First, if the custom is passive on the side of the suffering party, then it might, only might, not will, it might be maintained spontaneously due to the indolence, inattention, or a sense of a moral obligation of the suffering party. A man may have let another walk over his ground either because he has not mandated it, or because having mandated it he has not thought it was his while to hinder them, or because he has thought it hard, unsocial, or uncharitable to hinder them. Second, if a custom is active in the burdened party, for example, providing service, then its maintenance is least likely to be spontaneous. Attention is indispensable to the continuity of actions of service. Indolence militates against the maintenance of it. The sense of moral obligation in such case rarely has place, though it should have place. It would be too weak to overcome the joint influence of indolence and interest. So, at least, now we can say that the immemoriality that Blackstone claims for customs is, according to Bentham, is absurd.